Everyone, it is in fact Tuesday, March 10th, 2026, and I call this meeting of the Senate Elections Committee to order. We do have a quorum. It is 3:06 p.m. That's my passive-aggressive way of saying we're getting a little late start here. Okay. I want to welcome the audience to the Minnesota State Elections Committee. We appreciate your interest and participation in the legislative process. To ensure everyone can view, hear, and understand today's proceedings, we ask for your cooperation in maintaining decorum and civility throughout this hearing. For the safety, security, and comfort of all of our attendees, please note the following guidelines. As the acting chair of the Elections Committee, my job is to make sure our committee runs smoothly and efficiently, and to ensure we are able to complete our business each time we meet. My job is also to establish expectations around conduct during our hearing as follows. Signs and placards are not permitted in the hearing room. Verbal outbursts, shouting, or disruptive behavior will not be tolerated. Applause or other audible demonstrations are not allowed. For safety reasons, everyone must be seated. No standing, sitting, or pacing in the walkways or aisles will be allowed, nor standing or obstructing proceedings at your seat. However, if you do require a reasonable accommodation, please speak with our sergeant staff for your assistance with your needs. Sergeant-at-Arms are here to ensure everyone's safety. Testifiers have signed up in advance and have been provided with a time limit for their testimony. Please adhere to these limits so that all of our testifiers have the opportunity to share their thoughts and so that we can keep our meeting on time. If time runs out, I will ask you to wrap up your remarks. Before and after the committee, please talk to a sergeant if you'd like to speak with the senator or staff instead of approaching the committee table. The sergeant will let us know. If these guidelines are not followed, I will provide a warning and ask that decorum be restored. After that, ongoing failure to comply may result in removal from the hearing room. Our goal is to conduct these proceedings efficiently while ensuring everyone the opportunity to observe and participate appropriately and to maintain decorum. One other item I'd like to note, except for authors' amendments, we will have roll calls for all votes since we do have members participating remotely. There are 3 items on the agenda today, and we will begin today's agenda with Senate File 4147, which is Senator Boldon's bill. Senator Boldon, when you are ready, if you can go ahead and take a seat at the table, introduce yourself, and then begin with your bill.
Thank you, Madam Chair and members. I am grateful to be before you with this bill today. We have had many conversations in this committee about money in elections and dark money in elections and spending in elections and transparency in elections. And so this is a bill to get at just that transparency and to more clearly center the voices of people in our elections, as it should be. The Citizens United Supreme Court decision in 2010 opened the door for unlimited dark money, corporate, and special interest spending in elections, giving wealthy actors outsized influence and drowning out the voices of everyday voters. By treating corporate political spending as the equivalent of free speech, the decision weakened long-standing anti-corruption safeguards and fueled the rise of dark money spent without transparency. The result is a political system more vulnerable to hidden influence, less accountable to the public, and increasingly distorted by money rather than the will of the people. And this is a growing problem. Outside spending on elections nationwide prior to Citizens United was $144 million in 2008. That number has increased to over $4.5 billion in 2024. That's a 2,800% increase. A report from the U of M Humphrey School of Public Affairs found that over half of spending in the most competitive races in the 2020 election in Minnesota was dark money. State elections in Minnesota in 2024 attracted over $25 million in outside spending, over half of which did not fully disclose their source of the funding. This bill would require all political spending to go through transparent channels, principal campaign committees, which require contributions to be disclosed. The public has a right to know who is spending money to try to influence their vote. And this is a unique approach, I will say. We have had many, as I said, many conversations in this committee, and there have been many efforts across the country since the Citizens United decision in 2010 to sort of find ways around this or add transparency into the system. This is a unique approach in that it utilizes the expressed and very clear responsibility and power of the state who determines powers of corporations. That is our role as a state. That is very clear, that we determine what the powers of corporations are. And so we have the ability to do that. And so this bill removes all of the powers of corporate entities and then gives back most of the powers, all of them except for the ability to spend in elections. And so with the, again, the goal, end goal being that transparency and disclosure and putting the voices of Minnesotans back at the center of our elections. And so I know we have a number of testifiers, Madam Chair, so happy to move to those when you're ready.
Senator Boldon, do we want to take care of the amendments first?
Certainly.
Okay. So today we have a two-part process here to get the bill into the form that Senator Boldon desires. There is the A1 amendment, which is a DE amendment that was posted earlier this week. And then there is an A3, which amends the DE that was posted this morning. So Senator Boldon will first move the A3 amendment, and then she will move the A1 as amended. Senator Boldon, would you like to move the A3 amendment?
Yes, Madam Chair.
All right. All those in favor of the A3 amendment say aye. Aye. Opposed? All right. That amendment, the A3 amendment to the A1's author amendment is adopted. And then Senator Boldon moves the A1 author's amendment as amended. All those in favor say aye. Aye. Opposed? The A1 amendment is, as amended, is adopted. Senator Boldon, should we move to testimony then, or do you want to, any further comments about the bill? All right. So our first testifier today is via Zoom. We have Eric Petrie from the Brennan Center for Justice. And if you can come on camera, unmute yourself, introduce yourself, and go ahead with your testimony.
Good afternoon, and thank you so much for the opportunity to testify today. My name is Eric Petrie. I'm a counsel in the Elections and Government program at the Brennan Center for Justice, where I work to address issues related to money in politics. The focus of my testimony echoes some of the overview that Senator Boldon just gave about the problems that have resulted from the Supreme Court's decisions in Citizens United and other cases. When the court decided Citizens United in 2010, it swept away a century's worth of campaign finance safeguards. While it purported to address specific questions of corporate political speech, the decision actually swept much more broadly and invalidated virtually all limits on so-called independent expenditures, or money that does not go directly to a candidate or a party. The decision also paved the way for super PACs, which are groups that can raise and spend unlimited amounts as long as they operate independently from campaigns. These changes have had a profound impact on American elections, completely reshaping them. In the 2024 election cycle, for example, just 300 billionaires and their families accounted for nearly a fifth of all federal election spending. By contrast, in the election cycle immediately before Citizens United was decided, their share of spending was less than 1%. A core premise of the Citizens United decision was that this new spending would be transparent, so voters would know the identity of those trying to influence them. But that has not been the case. In fact, the Brennan Center's research shows that dark money groups that don't disclose their donors have spent over $4 billion in federal elections since Citizens United. The court also assumed that outside groups would be required to operate independently, but loopholes in the law and lax enforcement have meant that super PACs increasingly work hand in glove with candidates. They often share staff, fundraise alongside candidates, and even conduct core campaign functions like door-to-door canvassing. These activities clearly would have been illegal before Citizens United, but now they're common practice. Finally, the court's decisions have made it easier for bad actors to evade the rules remaining on the books, including the bar against foreign entities spending in American elections. Minnesota has certainly not been immune to these national trends. To the contrary, as Senator Boldon noted, outside groups have flooded the state's federal and state elections, with independent expenditures now making up the majority of spending in state legislative races. The reality is that the Supreme Court's decisions hollowing out campaign finance safeguards have fueled a crisis of confidence in American democratic institutions. Today, record numbers of Americans say they don't have faith in government, and they often say that's because the wealthy and powerful have too much sway over election and policy outcomes. We applaud you for drawing attention to these issues and for your continued efforts to develop innovative solutions to address them. Thank you.
Thank you for your testimony. Folks, we are having a little bit of a technical difficulty with the Zoom and are trying to fix that so we can spotlight speakers. So please just be patient as our staff works to correct that issue. Tom Moore is also on Zoom. He is from the Center for American Progress. And again, if you can come on camera, introduce yourself, and go ahead and provide your testimony, I'd appreciate it.
Thank you, Chair, and members of the committee, for the opportunity to testify virtually in strong support of SF 4147 as amended. And thank you for Senator Boldon for pursuing this so boldly. My name is Tom Moore. I'm a senior fellow for democracy policy at the Center for American Progress. Before that, I was senior counsel and chief of staff to Chair Ellen Weintraub of the Federal Election Commission. And today I come to you with good news. For 16 years, we've all been told that the only way to undo Citizens United is through a federal constitutional amendment or a new Supreme Court. But there is another way. It is brand new, it is shockingly simple, but it's based on 200 years of foundational corporation law, and it's before you today in SF 4147. All Minnesota has to do to get corporations out of its politics is decide to no longer grant corporations the power to spend in its politics. That's it. That is the core distinction, corporate rights versus corporate powers. The Supreme Court has been asked over and over again whether corporations have a right to spend in politics. What it has never been asked, and it's never said, is that corporations must have the power to spend in politics in the first place. As Justice Scalia wrote in his Citizens United concurrence, to be sure, in 1791, as now, corporations could pursue only the objectives set forth in their charters. If Minnesota defines its artificial entities like corporations as entities without political spending power, that's it. They've been redefined and there's nothing for Citizens United to cover or protect. Here's the clearest way I know how to explain it. You and I do not have the power to fly. And I mean flap our arms and fly. Our Creator did not give us that power. Birds, bats, yes. People, no. Now, if the Supreme Court announced tomorrow that humans had a constitutional right to fly, none of us would head to the roof of the Minnesota Capitol building to test that. Because no court can change the underlying reality that humans simply don't have the power to fly. And corporations are the same. Minnesota created
Okay, I mean, I'm hanging by a thread waiting for that sentence to finish. Why don't we take a moment? I guess this would be a good time to reboot the Zoom and try and get everybody back on the Zoom. We are going to very, very briefly recess. Please don't go anywhere, but you can talk amongst yourselves.
sitting in Minnesota law for a very long time. You have always had the power. And SF 4147 is, I suspect, how many of you are learning that you have it for the first time. Getting this bill passed in law is not going to be as simple as tapping your ruby slippers together 3 times. It's going to take some real effort and some real political courage. But it's what the people of Minnesota want and deserve. Many elected leaders, including members of this committee I'm speaking to, I'm sure, have decried Citizens United over the years. We have all talked the talk. SF 4147 is our opportunity to walk the walk. I look forward to your questions.
Thank you so much. Again, apologize for the technical difficulties, but appreciate your testimony. Now I am going to call up several people at a time to the testifier table. I'm going to call up David Fisher from Clean Elections Minnesota, Brian Cook from the Minnesota Chamber of Commerce, and actually, let's do those two. Take a seat on either side of Senator Boldon. And we'll start with David Fisher. Once you get settled in, go ahead and introduce yourself, and please go forward with your testimony.
Chair Westlin, good afternoon, and members of the committee. My name is David Fisher. I'm a career corporate lawyer. I teach business law at the University of Minnesota Law School and have so at St. Thomas Law School as well. I'm a former Minnesota State Commissioner, a former member of the Metropolitan Council, so I've been around a while. And I'm currently an election judge in Hennepin County. Today I represent Clean Elections Minnesota. You've heard of them before, perhaps, a nonprofit, nonpartisan organization working for an inclusive and healthy democracy in Minnesota. We support Senate File 4147 concerning corporate powers, provisions, and modifications. Just as a brief background, as you heard from other testifiers here today, we believe that the foundation of our democracy, our chosen system of governance, is that each of us have value, that each of us has a say, that each of us, if we are truly to be free, have the right to be heard, that each of us has the right, indeed, the obligation to vote and have that vote counted. In that now famous 2010 decisions of Citizens United, which you've heard about, it was held that independent expenditures could not corrupt and could not even create the appearance of corruption. Later courts interpreting that to impose limits on contributions that they are holding that limits on those contributions are unconstitutional. And with that, Super PAC was born and dark money groups took off. The consequences are swift. As you heard from Brennan Center, I'll just emphasize a bit more of what they found. In 2008, outside groups spent just $144 million on federal elections. By 2012, the first presidential election under the new rules, outside spending surged to more than $1 billion, and in 2024, it reached $4.2 billion, with a few hundred donors accounting for the overwhelming majority. As a matter of fact, in 2012, the top 1% of Super PAC donors provided 77% of the dollars spent. In 2024, that figure rose from 77% to 97%. Individual voters like me contributing $10 or $50, maybe $500 to a political campaign are simply overwhelmed by this abundance of money. So most people assume the only way to stop corporate big money and dark money in American politics is to either wait for the Supreme Court to overturn Citizens United, that will be a while, or amend the U.S. Constitution, which is itself extraordinarily difficult. But we believe there is another way, as the Center for American Progress has indicated, and we think it will work. And this is addressed in Senate File 4147 today. Corporations are artificial, juridical persons with the power to perform commercial activities, such as entering into a contract or owning property. In American law, corporations obtain these powers directly from the states, from people in this room, granting them authority to conduct business in the state. In other words, corporations are creatures of state law. For more than 2 centuries, as acknowledged by hundreds of court decisions, the power to define corporate form, limits, and privileges has belonged only to the states and to the state legislature. So this isn't about corporate rights, as was held in the Supreme Court Citizens United decision. This is about corporate powers. When a state exercises its authority to define corporations as entities without the power to spend in politics, corporations will it will no longer be relevant in that case whether corporations have a right to spend in politics, because without the power to do so, the right to do so has no meaning. So the solution is this: clarify your legislative intent in state statute that enumerates powers a corporation has to conduct business in the state, such that those powers shall be not be deemed or interpreted as granting a power that isn't there, use of independent resources to influence elections in our state is not there, and the legislature, I do not believe, ever intended it to be there. That is a matter of court interpretation of your statutes. Senate File 4147 addresses the solution. It's an effort to return our voters to a true say in our elections without being overwhelmed and drowned out by the massive amount of corporate dark money we've seen in recent elections. So Clean Elections Minnesota urges this committee to take action favorable to the bill. Thank you very much.
Thank you so much, Mr. Fisher. Mr. Cook, go ahead and introduce yourself for the record and proceed with your testimony.
Chair Carlson, Vice Chair Westlin, members of the Elections Committee, good afternoon. My name is Brian Cook. I'm the Director of Taxes, Fiscal Policy, and Elections for the Minnesota Chamber of Commerce, representing over 6,300 member companies with over 500,000 employees. Appreciate the opportunity for us to share with you our opposition to Senate File 4147. While we are approaching the bill from a business lens, it's also important to note that it would apply to entities, whether they are businesses or nonprofit organizations. The concept behind this bill originates from a September report by the Center for American Progress. While the bill states that this is a constitutional approach to removing the recognized free speech rights of entities operating in Minnesota, there are numerous constitutional issues, many raised in that report itself, such as the doctrine of unconstitutional conditions. This doctrine holds that the government may not require persons to give up their constitutionally protected rights, in this case, their First Amendment rights to free speech, in order to receive a public benefit, in this case, the ability to exist, operate, and do business in the state of Minnesota. The bill is also expansive in that, in addition to seeking to thwart election activity or political speech, it also seeks to block businesses from participating in ballot issue activity, which has been protected speech since the 1978 First National Bank of Boston versus Ballot decision. Ballot issues, whether city charter amendments or state constitutional amendments, can have direct and profound impacts on businesses. They have a right to share those impacts with voters, and voters have a right to hear them. We're also concerned that the additional prohibition on electioneering communications that was just adopted in the A3 amendment may also bring in issue advocacy and lobbying speech. Instead of Minnesota being the first state in the country to pursue this at best constitutionally dubious bill, we recommend it undergo judicial scrutiny elsewhere first. As a reminder, on May 5th, 2023, Governor Walz signed House File 3 into law. That bill contained provisions that amended Minnesota Statutes 211B.15 to bar so-called foreign influence corporations from exercising their constitutional rights to participate in political speech. This proposal raised serious constitutional questions throughout the legislative process, including in this committee. As a result of that law's enactment, on behalf of our members' rights, the Minnesota Chamber of Commerce filed a lawsuit in federal court challenging the constitutionality of that law on June 30th, 2023. Defendants in that suit were John Choi in his capacity as the Ramsey County Attorney and the Minnesota Campaign Finance and Public Disclosure Board. On December 20th, 2023, Judge Tostrud granted us a preliminary injunction preventing that law from taking effect as scheduled on January 1st, 2024. Then, on February 7th, 2025, Judge Tostrud ruled in our favor on summary judgment, permanently blocking enforcement of the law. Because the Chamber prevailed in that federal civil rights suit, we were able to recover legal costs from the defendants, which necessitated a $760,000 appropriation to the Campaign Finance Board in last year's state government finance bill. It's also important to note that the same originators of the so-called Foreign Influence Corporation law, the Center for American Progress, are the same originators of this new corporate charter approach. Their recommendations have already cost Minnesota taxpayers hundreds of thousands of dollars, and we urge the committee to reject this new attempt at prohibiting free speech and oppose Senate File 4147. Thank you.
Thank you for your testimony, Mr. Cook. Up next, we'll have Andrew Irvin and Jeff Clark. Mr. Irvin, once you settle in, go ahead and introduce yourself and you can proceed with your testimony.
Thank you. Andrew Irvin, and I live in White Bear Lake. And Chair Westlin, I'm here as a citizen very interested in restraining corporate and wealthy individuals' monetary influence in elections. Senate File 4147 does make a good step towards this goal in Minnesota. I am pleased that this bill clearly lays out that corporations do not have rights in influencing elections through money. This is critical. Court decisions, and of course we all are highlighting Citizens United, have given corporations a free hand in spending to influence elections. Senate File 4147 will recapture some limits in election activity in Minnesota. I do support this bill and ask that the committee pass it. However, I am concerned that it appears to not address the involvement of large categories of groups that focus solely on election activity. In 2024, there were 8 independent expenditure groups as one category that each raised and spent over $1 million each on state-level election activity. The 2 largest, supporting progressive candidates and causes, together raised and spent over $7 million. Groups supporting conservative candidates and causes followed with other significant amounts of spending. These groups are not inherently evil, and indeed I contribute modest amounts to one of the groups much farther down the list. But they do allow wealthy individuals to have an outsized role in Minnesota elections. But again, I fully support this bill and hope that it will pass. And thank you for the opportunity to present this testimony.
Thank you, Mr. Irvin. Mr. Clark, if you'd like to introduce yourself and proceed with testimony.
Thank you. My name is Jeff Clark. I'm a resident of St. Paul. Acting Chair Westlin and members, I'm testifying as a citizen who wants to strengthen fair elections and reverse the negative effects of the Citizens United decision of 2010, as well as ultimately reversing corporate power exercised in our government by means of presumed constitutional rights other than those in the First Amendment. Senate File 4147 and appendices are a modest and sensible step in the direction of curbing the effects of money on elections by working around the Citizens United decision that recognizes spending money in the campaign process as more or less equivalent to free speech and therefore, in the court's opinion, not subject to most limitations. SF 4147 denies corporate entities the power of campaign spending on behalf of corporate interests, basing this action on the requirements of their chartering or incorporation as creations of the state. This chartering process precedes their existence and activity as legal persons per the court and is largely controlled by the states, much as the states are granted the constitutional authority to administer their own elections. Thus, any state should be able to define a legal entity created by itself as having no privilege to spend money in the election process. Thus, a violation of free speech, thus a violation of free speech right never comes into question. SF 4147 simply involves a strategy which other states are also pursuing right now, Montana perhaps first among them. SF 4147 can't solve our big money in politics problem alone. It cannot restrict PACs, committees, funds, and variants of these, which are solely created and administered for electioneering purposes. It does, however, prevent corporate business entities from engaging in the same activities themselves, including creating their own PACs for that purpose. 4147 is an admirable first step in regaining control of elections that will better represent the constituents who vote in them and must live with their consequences. It should be much easier, in theory, to pass this than a longer-term solution such as a federal constitutional amendment to curb money and corporate power in politics and government. That legal instrument can be more comprehensive in scope and, though harder to achieve, more durable if it is. The best formulation of such an amendment is SF 569, which petitions Congress to draft one. That bill was heard and approved by the Elections Committee at the February 11th, 2025 hearing. I urge your support of the current bill and thank you for your time.
Thank you, Mr. Clark. Next up, we have Devin Abraham, owner of Once Upon a Crime, on Zoom. Go ahead and unmute yourself, and you can begin with your testimony. I think you're still on mute. Oh, there you go. Thank you.
This is sorry, I'm tuning in for volume on my phone. My name is Devin Abraham, and I own a small business in Minneapolis called Once Upon a Crime Bookstore. Thank you for taking my testimony today in favor of SF 4147. The U.S. Supreme Court's decision in Citizens United unleashed a flood of money from huge corporations and their wealthy executives, drowning out the voices of regular people, including small business owners like myself. It also allowed corporate and wealthy donors to hide their influence by directing their contributions through one or more for-profit or nonprofit corporations. All of this has only increased the power of mega corporations and their billionaire owners to the detriment of the rest of us. It is no surprise that Congress has adopted huge tax breaks, loosened regulations, and privatized what should be public services. They're doing the bidding of the huge corporate interests that fund their campaigns. This needs to end. Corporations of all kinds are artificial creations and should not have a say in our politics. Allowing corporate entities of any kind to spend on elections gives their wealthy executives two avenues for influencing elections, from their own pockets and from the corporate coffers, which is fundamentally unfair. Spending in elections should be limited to actual people, and all large contributions should be disclosed. If you'd be embarrassed to support a particular candidate, then you shouldn't make the contribution. As the owner of a corporation that would be impacted by this ruling, I fully support the state of Minnesota taking action to put an end to corporate spending in our elections and an end to corporations acting as pass-through entities to hide the source of donations. I'd be happy to own a corporation that does not have the power to influence elections. These are roles that should be reserved for we, the people. Stopping corporate money in our elections will move us towards a government truly of the people, by the people, for the people, that will support policies to help all of us thrive. Please support SF 4147. Thank you.
Thank you so much for your testimony. And our last testifier on the list is Katie Cashman, former Minneapolis City Council member. Go ahead and take a seat, make yourself comfortable, and then if you can introduce yourself for the record before you start your testimony.
Thank you, Madam Chair. My name is Katie Cashman. I'm a Minneapolis resident and a former City Council member. I'm here today to testify in support of Senate File 4147. I thank Senator Boldon and Senator Marty for bringing this bill forward. Minnesota voters of all parties agree that money in politics is eroding our democracy. For us to trust that our democracy and our government is really working for us, we need to take action to get big money out of politics. Our elections provide us with the opportunity to elect community leaders that help us improve our lives. When I ran for City Council in 2023, I was so proud to help thousands of renters and young people and newcomers to our state cast a ballot in a local election for the first time, and to make their voices heard on the issues that matter to them. And I was so proud to represent their interests on the council. But the 2025 municipal election in Minneapolis was different. Last year, our city's elections were flooded by corporate spending to a degree I had never experienced. In Ward 7 alone, 3 corporate PACs spent $140,000 to defeat just a city council campaign. And together, those PACs spent more than $2 million to influence the Minneapolis municipal election. Under our current campaign finance system, they were able to raise and spend these huge piles of cash to sow confusion and distrust in the election before quickly shutting down and opening up under a new name, avoiding public scrutiny and accountability. The PACs are called All of Minneapolis, We Love Minneapolis, and Thrive Minneapolis, and they are funded by business associations like the Regional Chamber of Commerce, the Downtown Council, National Retail Federation, and Multifamily Housing Association. These entities wanted more corporate influence on the council and less power for workers and renters and the people who actually live in the city. During and after the election, many of us felt disenfranchised, like the special interests from outside of the city had more influence than us as actual residents. And I want to live in a democracy where we can fairly and equally use our voices to shape our future. We need this legislation to ensure that candidates and elected officials are accountable to voters, not corporate groups. So I hope that Democrats and Republicans will vote yes to make our government more accountable to the people it serves. Thank you so much.
Thank you so much for At this time, are there any additional amendments? We'll put you on the list. We'll get to you. Are there any additional amendments for this bill before we move on to questions and comments? Do you have an amendment, Senator? Oh, we'll get you on the list. Okay. Senator Port, I think you were the first person on my list.
Thank you, Madam Chair. Thank you, Senator Boldon, for bringing this bill. I wonder, Mr. Fisher, if I could have you come up and just repeat the numbers that you said for 2020 and 2024 and the amount of spending by, I think you said the top 1% of donors.
Mr. Fisher, if you can just note your name again for the record and go ahead.
Yes, Senator Westlin, thank you. Again, my name is David Fisher, representing Clean Elections Minnesota here today. And Senator Port, in response to your question, what I was saying is that the Brennan Center has done a fair amount of research, so we rely a lot on them as you do. But what they're saying is that in 2008, this is 2 years before Citizens United, outside groups spent about $144 million on federal elections. In 2012, this is the first cycle after Citizens United, that outside spending surged to more than $1 billion. In 2024, it reached $4.2 billion, with a few hundred donors accounting for the overwhelming majority. I didn't mention this, but I'll mention it now. One super PAC in 2024 received a single $205 million dark money transfer from an affiliated nonprofit. In 2012, this is the one you mentioned, Senator Porter, the top 1% of super PAC donors provided 77% of all funds. In 2024, that figure rose from 77% to 97%.
Senator Port.
Thank you, Madam Chair. Thank you, Mr. Fisher. That is an astounding number. I think we've all known, this power has grown and grown and grown, but 97% of that super PAC funding is, I don't have nice words to say about how the impact that has on our democracy. I think we hear from voters more and more that they want a government that's accountable to them. And I don't know how any of us can look at this system and say that our election system is accountable to voters when money, we know money has power, is that disconnected from an average voter. That is a mind-blowing and astounding number. Senator Boldon, I really appreciate this bill. I think it is a novel, interesting approach. And I think we're at the point where we have a problem that cannot continue to just be pushed down the road. I think we're seeing the impacts of what having these huge amounts of money by a very few people be able to buy elections has on governing. It is incredibly difficult to, have people give you millions or hundreds of millions of dollars to get elected and then not expect that they will want something in return. And I think we are seeing so much of that. We're seeing government contracts. We're seeing very odd and, unqualified people in roles that they have no business being in or had no business being in, who were those really large donors in this last election. And I think we need to go back to that accountability to voters. This is a piece of the puzzle. I don't think it's a silver bullet. I think we've got lots of problems, but I think if you take this and you combine it with some of the other things that we've been talking about and working on, I think you start to get back to an election system where money doesn't just completely overpower all of the other voices in the arena. I'm not going to lie, this is probably going to be a really hard bill to pass. There's going to be big money who's interested in us not doing this. There's going to be lots of people from, I think, both sides of the aisle who spend a lot of money on both sides of the aisle who are going to be pretty crabby about us having this conversation, but I think it is a critical piece of the puzzle. I'm really excited that we're thinking about new ways that we can have this conversation. I don't envy you and the conversations I'm sure you're going to get after this, but I think this is really one of the first new approaches since 2008 that we've really heard about that has a potential to really curb back this money. So thank you very much, Senator Boldon. Thank you, Mr. Fisher.
Thank you, Senator Port. Up next, we have Senator Barr.
Oh, so that was a short list. Thank you. I have a couple of questions. First off, let me say thank you for offering this. We've all had on around the committee table here had many of conversations about this is a problem. Totally agree. My questions come from two of your testifiers, Mr. Irving and Mr. Clark. Both testified that there's still going to be holes in spending. So the questions come in: how does this affect IEs? How does this affect? Your testifiers mentioned certain big donors. Would this have any effect on a big donor, somebody who has millions to spend? Let's just say multi-billionaire, any multi-billionaire. Would this stop them from coming in, buying TV time, and saying, "I paid for it. I can have my 30-minute infomercial on the television," because they could afford something like that? I just want to grasp all of the nuts and bolts about how does this, because what I'm reading is corporations. So how does it affect the IEs, things like that? Could an individual still give money to the IE that comes back and spends tons of money? Could they buy their own advertising time, send their own flyers, and just paid for by Bill Smith, billionaire, that kind of thing. So could you just address some of those, please?
Senator Boldon. Thank you, Madam Chair. Thank you, Senator Barr, for the question. So this bill it encompasses and would affect everyone who is not a natural person, a living, breathing human. So it impacts corporations, and you'll see the definition for legal entity, which includes we'll have, this bill is intended to go to the Judiciary Committee, where we'll have much more conversation about sort of corporate structures and those type of things, but it encompasses all entities, so nonprofits, corporations, LLCs, et cetera, with the exception of PACs, who are explicitly built and designated for political spending and have regulation and tracking, so that is made public and known. And so I would also just then point your attention to in the A3 line 1.10, which talks about political spending powers. And so this does encompass spending in elections, both for a candidate, for issues. It talks about aid, promote, support, or defeat the endorsement, nomination of a election of candidates in every level, federal, state, or local. It talks about electioneering communication. It includes support, actions to support or defeat the interests of any political party, political committee, or fund, or similar entity. Aiding and promoting, supporting the defeat, passage of a ballot question, recall a constitutional amendment, charter amendment. And so it is meant to be encompassing of sort of all spending related to elections.
I think Mr. Moore had his hand up. Mr. Moore, did you want to respond more to that question as well?
Thank you. Yes, appreciate the opportunity. This is the Senator is exactly right. This affects only artificial entities spending. And if you are a multi-billionaire who wants to drop $250 million into a super PAC and have that super PAC spend the money, this does not affect that. It's like one miracle at a time. Harvard professor Larry Lessig is working on this with a lawsuit that's going through the First Circuit that would regulate super PACs like PACs, which would actually take care of that. These two reforms together would actually handle the entire problem. What this will do is prevent that multi-billionaire from giving his money or her money to a 501c4 dark money group, which then gives it to the super PAC, which discloses the name of the dark money group, but not the name of the billionaire. So at the end of this, if you do pass this, all the money in your system will come from individuals, and all of it will be disclosed. And that is a massive improvement from what you have right now. It's not everything. It is absolutely not everything. But it's a big difference from what we've been experiencing for the last 16 years.
Thanks, Mr. Moore. Senator Barr.
Thank you, Madam Chair. Could Mr. Irving come back up? I just wanted to check a couple of the numbers you had with, and I'll, as you're walking up, I'll kind of ask my question, but you did mention there was 8 super PACs, I believe, that gave, was it 8? Yeah, go ahead and talk about your super PAC money, please.
Mr. Irvin, go ahead.
Irvin.
Andrew Irvin, Senator Barr, it was 8 independent expenditure groups, and I'm using the category used by the Campaign Finance Board. And I'm drawing my numbers from an article in the Min Post, which actually did a very good job of synthesizing information, and there was actually a great deal more than what I've mentioned there. So there were 8 independent expenditure groups involved in state-level elections in 2024 that each raised and spent more than $1 million each. So I don't know if that's helpful, Senator.
Senator Barr.
Thank you, Madam Chair. It wasn't what I was looking for, but so I misunderstood you. I was thinking you were talking about the super PACs, which is where the real bulk of the money comes. And I'm kind of interested to hear how the lawsuit that was just mentioned comes in on that one, because I believe that's where the real problem is in the super PAC. That's where your true dark money is at. Many of us have talked about this, that personally, I'm just going to run down what I think it should look like. And granted, I want to applaud you for doing what you're doing, because I think it's commendable that this needs to be addressed. It needs to be fixed. Totally get that. Senator Marty and I have had discussions about, the constitutional amendment, the bill that was mentioned earlier that he has proposed. I'd like to see you can only give money to a candidate. I don't care who it is, but I want to all go through a campaign committee. And we've talked about public funding. So if you publicly fund, you have to participate in long-form debates, things like that. But all the money needs to go through a political campaign. And I believe up until probably the last time, before Citizens United, the last time the federal government reformed campaign finance law, it all had to go through, because I remember when I was much younger than I am today, where the end of every TV ad or radio ad was, I have the funded and paid for by such and such a committee, and I approve this ad. Well, we took that away, so that creates the IEs, and then we do another Citizens United, and we find the way around with super PACs. And if we do this, where super PACs are still here, but we've just kind of created, I want to say, moved more of the money to go to the super PAC, so it takes even less authority away from the actual candidate, because you're going to just get flooded with nothing but super PACs, because everything in between is gone. It's either super PAC or candidate, and the pieces in the middle are going to, this will take out all the pieces in the middle. I like your ingenuity, your drive for this, but I'm not quite sure if this is where I want to go. But I totally agree that this needs to be reformed. So I don't have any more questions.
Thanks,
or comments.
Senator.
Thank you.
Mr. Moore, I see your hand is up again. Did you have some additional information to offer to Senator Barr or the committee?
Yes, thank you. I appreciate it. Let's see. It is true that money could still flow through super PACs the way it's flowing through now, but the source of the money into super PACs would be different. One of the things that it's difficult to grasp is that super PACs actually are political committees, like candidate committees, like party committees. They actually do have to disclose all their donors. It's in combination with these dark money groups, where the dark money groups give a giant amount of money to the super PAC, and then there's no real disclosure. That's the real problem. But if you've got a multi-billionaire who's giving money to a super PAC and they have to disclose that person's name, that actually has real value, real information for the voters, and they might actually be able to say, like, wait a minute, like, I didn't know who Americans for a Better tomorrow are, but I do know who Elon Musk is, and I don't appreciate the fact that Elon Musk is buying this election. That's what happened in Michigan with the Supreme Court elections last year, and it's when what we have seen since Citizens United was decided is not multi-billionaires putting their money on all their spending. It's them hiding their spending through these dark money groups. So this would be a major change, not in how super PACs operate. That's, again, what Professor Lessig is working on in Maine. But it would absolutely affect the kind of money that can come into a super PAC. And the only kind that would come in would be from disclosed individuals. So that would be a major, major change.
Thank you, Mr. Moore. All right, next up, Senator Lucero.
Thank you, Madam Chair. I have several questions here. The first is, Senator Boldon, in your opening remarks, you referenced transparency, and I'm just seeking to confirm that this bill is seeking to increase transparency on the political influence or political spending of businesses, or does this bill, as amended, seek to prohibit spending and influence in elections by businesses?
Senator Boldon.
Thank you, Madam Chair. Thank you for the question, Senator Lucero. So this bill would not allow spending in elections from these legal entities. It would be limited to humans, natural humans, and then it would have to go through, again, PACs where there's disclosures, whether there's tracking, and those pieces. And so there are limitations certainly built into that. And what I mean by transparency is then it removes the dark money that we're talking about, the Minnesotans for hot dish, and we don't know who's contributing. Like, what does that mean? Who is that? The spending that is left would be that which is transparent and disclosed and known.
Senator Lucero.
Thank you, Madam Chair, and thank you, Senator Boldon. Next question, Senator Boldon, does the state of Minnesota tax business entities in the same way that it taxes individuals?
Senator Boldon.
Thank you, Madam Chair. Senator Lucero, not serving on the tax committee and not being a tax expert, I'm not going to get into all the details of taxing, and I'm not. There's certainly differences in, there's many taxes on corporations, businesses, LLCs, people. I guess I'm not answering maybe in the way that you want. There's many different taxes that come on different entities in many different ways. I'm not sure.
I'm also not a tax expert. I'll just say my business is set up as an S corp, and so my business itself doesn't get taxed. It's all passed through to me as an individual. So I think it depends on the entity. But go ahead, Senator.
Thank you, Madam Chair. Senator Boldon, does the state of Minnesota impose mandates and regulations on businesses as mandates, regulations, criminal law, other limitations are placed on individuals?
Senator Boldon.
I'm going to be, thank you, Madam Chair. Does the state of Minnesota pass mandates for businesses? I suppose that it does. I will say, again, I want to root us in the bill. The state of Minnesota has the explicit responsibility of granting powers to corporations, businesses, legal entities, and that is the root of this bill, is that it is solely within our discretion to say what powers these entities have and do not have.
Senator Lucero.
Thank you, Madam Chair. Thank you, Senator Boldon. It's very clear that businesses pay taxes in the state of Minnesota, just as individuals do. It's very clear that the state of Minnesota regulates businesses and imposes mandates on businesses, just as regulations, mandates are imposed on individuals. So now I would like to draw attention to line 2.7 through 2.8 of the bill as amended. This is the A3 amendment to the amendment. It reads, political spending powers are not necessary or convenient for a legal entity to carry out its legal entity's lawful business. Can you help me understand, Senator Boldon, what the intent of that language or what the meaning of that language was as you drafted it?
Senator Boldon.
Thank you, Madam Chair. I'm just reading the lines here. Senator Lucero, this language, and I would maybe welcome council's input as well.
I think Mr. Moore also has his hand up, so I don't know if, Mr. Moore, if you're able to answer that particular question from the A3 amendment. Oh, you're on mute.
Thank you, Madam Chair. The state of Minnesota currently gives all powers necessary and convenient to its businesses to do business. And the idea, the way the bill is structured, is to just not change that, is to stay within those words. So nobody has to worry about what's the universe of powers that you're now granting. And the idea is they had all necessary and convenient powers, and now they have all necessary and convenient powers except the political spending powers. And adding that line, it's kind of belt and suspenders and saying, like, look, no court, nobody anywhere should interpret necessary and convenient as meaning including political spending powers, which is kind of the mistake that the Citizens United Court made in the first place. And this is just the bill's way of making sure that mistake doesn't happen again by being very, very clear about what the state means about the powers that it's giving its corporations.
And I have asked Ms. Stengel, who said she would have said roughly what Mr. Moore said. So there's your answer. Senator Lucero.
I appreciate that, Madam Chair. So to Senator Boldon, do you agree with that statement?
Senator Boldon.
Madam Chair, do I agree with the statement, the language in the bill?
Language, yes.
Yes, I do. I also would just mention that it ties back and references back to line 1.10 of the A3, which defines political spending powers.
Senator Lucero.
Thank you, Madam Chair, and this is my final remark. It's very clear what's happening here. Democrats want to tax businesses. They want to impose regulations which have direct influence in either giving favoritism to certain businesses or harming businesses, maybe being punitive in certain industries. And Democrats go on to say then, despite the reality that Democrats raise taxes on businesses, that they increase regulations that hurt businesses, they say in the bill that political spending powers are not necessary or convenient for a legal entity, which is a business, to carry out the legal entity's lawful business. The two positions here are devoid of reality. A business absolutely needs to engage in the political process to conduct their business. As these mandates continue to be imposed, which cost jobs and might result in the business leaving Minnesota, laying people off, and critical business decisions. So I'm just highlighting, Madam Chair, Senator Boldon, that this bill, the language in the bill, is absolutely devoid of reality, and I'm opposed to the language as it's presented here. Thank you.
Thank you, Senator Lucero. Senator Matthews. Oh, Senator Boldon, I'm sorry.
That's okay. Thank you, Madam Chair. I would just note, businesses are not people. If a owner of a business wants to engage in the political process, make a donation, that's fine, and that happens, and that will continue to happen. Bill is not talking about natural people. This is talking about spending in our elections. There is nothing that makes it necessary for a business to spend money, especially in ways that are not transparent in an election.
Thank you, Senator Boldon. Senator Matthews.
Thank you, Madam Chair. One of the easy principles that continues to be missed as we're discussing this is that corporations are made up of people. And it is astounding to me the number of times the list got added to today of how many quotes or citations are presented to this committee, and it takes me about 15 seconds of an internet search to find it wildly taken out of context and easily disproven. And the one I went to go check on was the citation to Scalia's supposed quote and position in his concurrence in Citizens United. And I would urge everyone to go pull up the text of that. It's easily accessible on numerous websites, and read what he actually said, because it's wildly different than what was presented. The quote given about corporations only as far as their charters was couched in his response in rebuttal to the dissent in this opinion. And he went on to, I just pulled it up and read through it here, he went on to give his defense of speech, and he made an interesting point, which I think this committee needs to know about. All the provisions of the Bill of Rights set forth the rights of individual men and women, not, for example, of trees or polar bears, but the individual person's right to speak includes the right to speak in association with other individual persons. Surely the dissent does not believe that speech by the Republican Party or the Democratic Party can be censored because it is not the speech of an individual American. It is the speech of many individual Americans who have associated in a common cause, giving the leadership of the party the right to speak on their behalf. The association of individuals in a business corporation is no different, or at least it cannot be denied the right to speak on the simplistic ground that it is not an individual American. But to return to and summarize my principal point, which is the conformity of today's opinion with the original meaning of the First Amendment, the amendment is written in terms of speech, not speakers. Its text offers no foothold for excluding any category of speaker, from single individuals to partnerships of individuals to unincorporated associations of individuals to incorporated associations of individuals, and the dissent offers no evidence about the original meaning of the text to support any such exclusion. We are therefore simply left with the question whether the speech at issue in this case is speech covered by the First Amendment. No one says otherwise. So while that's a more lengthy quote, I thought that was important to weigh out what we're doing here. It's highlighting that the First Amendment right that all of us enjoy is the right to speech. And that includes many different forms. And I'm actually glad that the majority and those who appeared to be likely to pass this bill again want to clearly come out and are openly advocating, yes, we'd like to take away your right for speech in this manner. Because we were here before, a similar bill was tried here several years ago. Members on this committee warned you were going to be passing an unconstitutional bill that was likely going to be struck down in court. It went out of this committee and it went to the Senate floor, and we once again, in a very lengthy debate, reminded all of you that you were passing an unconstitutional bill that was likely going to be struck down by the court. And that in fact did happen before it had the chance to even take effect. And the result of that is the taxpayers, including the 80-some thousand people in my district, got to be put on the hook to pay for that needlessly legal bill that the state of Minnesota incurred. And that is my frustration with this, that we want to find a new way to take a novel approach to not be getting at real reform, dealing with even the most significant areas of reforming dark money, but go after one specific area in this more partisan type reform. And it's clearly and openly being discussed as a limitation on your speech and the ability to express your speech through the money that you choose to spend. I also want to highlight two parts of this bill. I guess I would ask the author why we have phrases that are within this, though I'm not sure if we'll get a satisfactory answer on it. But I want to ask, we've got towards the end of the bill in the A1 amendment, Section 7 reads to me like it is just claiming we'll just state in a law that a court can't touch our bill, and that they are not allowed to revive it or reinstate it or anything implied by operation of law or judicial construction. Is there any other example where we have put this in state statute, or any example where this has been tried in a court case and has been upheld, especially in a post-Marbury v. Madison role, where the judiciary is their role is to weigh the constitutionality of laws, and a court has looked at this and said, well, I guess the statute says we can't review it by judicial operation, so we can't touch this bill. Do you have any examples of this language in any other scenario?
Senator Boldon.
Thank you, Madam Chair. I don't, sitting before me, I'm happy to get back to you, and I don't know if Council has anything to add to that, but I don't in this moment sitting before me.
And just, Senator Matthews, I do notice Mr. Moore's hand is up again. I don't know if he has anything in response to your question. Mr. Moore, do you have anything you'd like to add?
Madam Chair, yes, thank you. And thank you for the opportunity. The Senator has challenged my scholarship, and I'd like to respond on that. The quote from Scalia is important because it's the only mention of powers in the entire Citizens United decision. And I would invite the Senator and his colleagues, all of you, to look through Citizens United and look through ballot and look through any of the other cases there and see if there's any hint that the Supreme Court has ever required a state to give powers to its corporations. It hasn't. It says once you do give the power, there are things that you can't do with the rights. And that's fine. But it has never, ever, ever said that you have to give them the powers. As to the Senator's second question about the non-revivability and that kind of thing, yes, that is fairly standard. Basically, that is a way of legislatures, it's a way of that legislatures tell courts how to review the statutes and what their preference is, and it does not say that you can't review it, but it does say that if you flip this statute, if you overturn it, do not revive what was there before. And that is the legislature's prerogative. And if the legislature is silent on that, courts will take a stab at what they meant about that, and maybe they meant for them to bring the old stuff back, or maybe they didn't. This is the way that the legislature tells courts, do not bring the old material back. And in some ways that gets to the real difference that you're dealing with here. You are not doing the regulatory power of the state. You're not using that power. That is when you restrict, when you require, when you forbid, all these different things. This is a positive power grant that's completely discretionary. It's a completely different authority that the state is offering here, and it hasn't been messed with in 100 years. None of you have ever seen a bill like this. There is no similar legislation. Your FIC legislation is not similar legislation. That was regulation. This is power granting, and the tools that a court has to deal with a state when it's power granting are completely different. And if basically, if it's got a power grant that you've given them 3 things and a court wants you to give them a 4th, it can't make you do that. And that's what that language in the bill is designed to do. It's what it's in the Montana version. This bill, similar language to this, has been introduced in something like 11 states now, and similar language is in every single version.
Thank you. Senator Matthews, go ahead.
Thank you, Madam Chair. And I appreciate this discussion. I'm going one level deeper, though, because this is not about a business has to comply with standard X versus standard Y, or regulation X versus regulation Y. The stated purpose of this bill is you must agree to give up your right to speak in the political environment as a condition of being incorporated. And that's a fundamental right granted in the Constitution. And that's why this is very different from all the other, I've read through some of these documents about why you believe this novel idea is going to work, and maybe you're going to have a chance where this will get tested by a court. But everything that I've read so far is it's coming back to there's a clearly stated goal by the authors to take away the fundamental right to speak in the political environment by those that are within corporations. And that gives me serious doubt that this will uphold scrutiny on that matter. And the same reason why A person does not have to give up their right to self-defense and defend themselves if they have joined an incorporated organization. Same way that you do not give up your right to be secure in your persons and things, and for the government to get a warrant to come and search your property, or any of the other fundamental rights that we enjoy in our Constitution. I appreciate the discussion and the back and forth on this, but I'm firmly in opposition to this bill. It feels like just more of the same that we have already tried to do and saddled my constituents with the legal bill for. Thank you.
Thank you, Senator Matthews. Senator Boldon.
Thank you, Madam Chair. I appreciate the opportunity to sort of re-ground us in what we're talking about here and the intent, which was, I want to be very clear on that because it was just wildly misstated. My intent of this bill is to center elections back on people, humans, real people, Minnesotans, who, as we have been talking about in this committee and have heard here today, are losing trust in our system because they feel that they don't have a voice because of the huge sums of dark money that are being spent in our elections. And so this is not a bill about speech. This is a bill about our democracy and spending money in elections. And there is nothing in this bill that stops any human from, engaging in elections, spending money in elections. That will continue. This is about legal entities and what they have the power to do, and ensuring that spending in our elections is transparent so people know who is spending where. I will also just say, this is not a partisan bill. I assure you I'm not making any new friends by bringing this bill because this impacts across the board. So it is not at all partisan. It impacts everyone equally.
Thank you, Senator Boldon. I have next up Senator Curran, and I have Senator Port and Senator Swadzinski. And just as a reminder, we do have a couple of more very exciting bills to get to. So I'm hoping that we can maybe get through our list here. Senator Curran, you're up next.
Madam Chair, I'll be brief. I could hardly say it better than Senator Matthews just covered. So I think our Senator Boldon, you said, yeah, you wanted to bring it back to center on the humans and the transparency. That's all great. But the Constitution and Supreme Court's getting in the way. I think we should not be the experiment again and spend hundreds of thousands of dollars to lose another lawsuit. I don't believe it will pass likely this body, nor will it pass the House. So thank you. Madam Chair, are you going to pass it on? You're going to vote this out?
This goes to Judiciary as the next step.
I've requested roll call.
Yep, already requested.
Oh, you said, I'm sorry, you said earlier. Yep,
I think because Senator
you.
Carlson can't be with us in person, we're just going to standard roll calls. Thank you, Senator Curran. Senator Port.
Thank you, Madam Chair. Sorry, I have so many things. Senator Boldon, does this bill stop co-owners of a business from starting a PAC and disclosing and giving their own money?
Madam Chair, no, it does not stop that.
Do you, thank you. Do you know of any businesses that exist in Minnesota that have no people associated with them?
Senator Boldon.
Thank you, Madam Chair. I am not aware of that, no.
Senator Boldon, do 16-year-olds who have jobs pay taxes?
Senator Boldon.
Madam Chair, yes, they do.
Do they have the ability
Senator Port. Senator Port,
Madam
can
Chair.
you let me keep the record straight here? Thank you. Senator, I love a good cross-examination, but just give me a breath.
Do they have the
Senator
ability
Port.
to vote?
Senator Boldon.
Thank you, Madam Chair. 16-year-olds do not have the ability to vote. Okay.
Senator Port.
Thank you, Madam Chair. We have all sorts of regulations on who can vote, who has the ability to own guns, who has the ability to, limits that we put on corporations because they have impacted communities with harm, pollution, and things like that. Have put lots of regulations on business that stop them from doing a thing that they want to do because it makes them money. The reason behind capitalist businesses, the reason our economy exists the way it does. I I would be fascinated to know what real reforms our colleagues across the aisle would be interested in, because they didn't support the 3 or 4 disclosure bills that we had last year. They didn't support elected officials being able to go and visit their constituents in apartment buildings. I'm guessing that when my bill on Thursday that increases fees and penalties for the large spenders in our political system when they obfuscate or lie and knowingly go against the rules of our campaign finance board, I'm predicting, I could be wrong, that they won't support that either. I think it is astounding to think like this system that we have with corporations being able to give as much money as they want and hide who is giving that money and who is speaking in our system is like the system you want to continue with. It blows my mind. I am delighted to know that Senator Matthews believes in due process. I wish our president did, but it's a thing that we have to be thinking about. What election systems do we want in the future? What do we want to build towards? And I don't want to build towards a system that the only voices you hear are the voices of the very incredibly uber rich in our country, and that is more and more and more what elections are turning into. It is perverting the process. It is corrupting what people hear and feel about their own elected officials, and I think it has a corrupting effect on this place too. It pits us against each other in a way that didn't used to be true. Senator Barr and I agree on a lot of things, but we're often like pitted against each other in something that we wouldn't disagree on otherwise. Thank you for bringing this bill. I think it will be fascinating to see how this conversation evolves as we move forward, but this seems like an absolutely critical piece of it.
All right, Senator Swedzinski, you're going to get the last word before we go to Senator Boldon.
Thank you, Senator Boldon. I have 4 things I want to get off my chest. And one, in my first campaign when I ran, and you go to the post office, the mailbox, and all of a sudden there'd be a bunch of literature in there, and you'd look at it, and there'd be literature for me saying vote for Senator, or not Senator, vote for this guy. And I'd be all excited. I'd like, who paid for this? It must have been my campaign, right? And I'd look at the bottom, and I don't even know who these people were that were paying for this. So I can't thank you enough for even bringing this conversation to the table. And Senator Port said you're not going to make a lot of friends. Well, you made one right here. So for what that's worth, if you ask anybody, name your 3 or 4 or 5 worst Supreme Court decisions in U.S. history. In my opinion, it's Dred Scott, it's Plessy, it's Korematsu, it's Bush versus Gore, and it's Citizens United. When I think if you took Hamilton and Madison and Washington and sat them behind you, and we had this very discussion, I don't think for the life of us they would remotely think that freedom of speech, of political speech, in a million years meant money. I don't think they would have ever even thought that way. In my humble opinion, they meant political speech was discourse and debate and deliberation. It never once ventured into their heads that someday the Supreme Court would say money counts as speech and corporations are people under the Constitution. How that Supreme Court, well, we know how it. Well, anyways, number 4, and finally, I just want to say, so I think the PCR forms were a way to get the little guy, the little person, the person with just a little pocket change to get them involved in the political process. And in the PCR form itself that we love to participate in, it asks, the first question it asks when you submit the form is, are you a U.S. citizen? Are you a voter? Can you imagine if we proposed a bill that said the PCR should be a 3rd item, are you a corporation? And I'm sure people would go, no, that's unacceptable. The PCR has to be for the average person so that they can participate in this wonderful thing called democracy with their humble $150 per couple or $75. And so I just can't thank you enough for even chipping away at what arguably, or in my opinion, is one of the 5 or 6 worst Supreme Court decisions in American history. Thank you for indulging me.
Senator Lucero, is this a new comment and new information? And could you just be brief, please? We got to get to 2 other bills.
Thank you, Madam Chair. Everything I say is new and relevant. That's not up for debate. Madam Chair, Senator Boldon, I think I agree with you. Let me start over. Senator Boldon, you are correct. People are losing trust in elections. But it's not for your assertions. People are losing trust in elections because the lack of election integrity. The rampant fraud that's occurring in our elections, exacerbated by Democrat provisions that they have passed in the last several years. It is very enlightening that there are at least 4 Democrats on this committee, the Elections Committee, that repeatedly demonstrate they don't even know what kind of government we are. A continual false assertion of our democracy, our democracy. I hear it over and over again. And in fact, even one member on this committee on the Senate floor, I asked, can you even admit what kind of government we actually are? And the inability to do so is mind-blowing. We are a republic. And so the very people that are trying to pass bills either knowingly are making false statements or are ignorant as to what kind of country we are. Thank you, Madam Chair.
Senator Lucero, I think all of us know that we have a republic. But I also think in the vernacular, if you ask any person out there who talks about this country, including our president and other presidents, has referred to it as a democracy. So I don't know that that's necessarily all that enlightening. And the other thing I guess I just have to push back on, senators, we keep hearing about this fraud in our elections. There's literally no evidence of that. Literally no evidence of any meaningful fraud in our elections. And you can keep saying the same thing over and over and over again, and repeating that same misinformation over and over again is not going to transform that into truth. Senator Boldon.
Thank you, Madam Chair. Members, I appreciate the conversation, and I will just say my door is open to anyone who wants to work on this issue. I would be happy to have a conversation and continue to do that because it is a problem. I'm not going to rehash the figures that we talked about, but the amount of dark money spending in our elections is a problem that we need to take action on. And we know that, but more importantly, Minnesotans know that. Minnesotans want something different. They want transparency and disclosure, and they know that they should have an idea of who is spending money in elections, who is trying to influence their vote or influence policy or whatever else it may be. And so I will continue to talk about democracy and work towards a more inclusive inclusive democracy, one that works for everyone, one that works for people, and that is what we are aiming with this bill to refocus elections on is people, humans, and not dark money entities who have unlimited spending power and are drowning out the voices of people. So thank you, Madam Chair.
Thank you, Senator Boldon. All right, Senator Boldon moves that SF 4147 as amended be recommended to pass and referred to the Judiciary Committee, hard to say. And we will take a roll call vote. Ms. Stankiewicz will take the roll.
Senator Westlin?
Aye.
Senator Curran?
No.
Senator Carlson?
Aye.
Senator Barr?
No.
Senator Boldon?
Aye.
Senator Swedzinski?
Yep.
Senator Limmer? No. Senator Lucero?
No.
Senator Marty?
Aye.
Senator Matthews?
No.
Senator Port.
Aye.
All right, there being 6 ayes and 5 nays, the bill is recommended to pass and it will be referred to Judiciary Committee. What? As amended. Okay, so we have 2 bills. I don't anticipate, I know one of the bills, Senator Cran is a co-author with me and has an amendment. I anticipate that these 2 bills should go relatively quickly, but I will say we are going to stay to complete our work on these last 2 bills.
All right, members, we are moving to Senate File 4223. Senator Westlin, I understand that you have an oral amendment that you would like to incorporate into your A1 author's amendment. Would you like to tell us about that, please?
I would, based on some feedback from Mr. Sigurdsson, I want to say that on the A1 amendment, Section 2, which is the first part of this bill, is going to have an immediate effective date. And then at the very end, 4.18, we will be removing the effective date. And my understanding then is this will automatically go into effect on August 1st of 2026. If I have any of that wrong, I would look to Ms. Stengel to correct me. But I believe those are the 2 corrections for the A1 amendment.
Ms. Stengel, could you please describe the oral amendment to us?
Thank you, Madam Chair and Senator Westlin. I have no corrections, but I can state the page and lines and the language that will be inserted. Looking at the A1 amendment, the language to be added would be on page 2 after line 2, insert effective date period. This section is effective the day following final enactment. And on page 4, delete line 18.
Members, any question about the oral amendment to the A1 amendment? Seeing none, all those in favor say aye.
Aye.
Aye. All those opposed say nay. The oral amendment is adopted. And we now move to have the A1 amendment before us with the oral amendment incorporated. Any other comments, Senator Westlin?
No, Madam Chair, and I think it probably makes sense to adopt the A1 amendment, and then I know Senator Cran has an additional amendment that we can take after the A1.
Very good. So members, we will adopt the A1 author's amendment. All those in favor say aye.
Aye.
Aye. All those opposed say nay. Amendment is adopted. Senator Westlin.
Senator Cran, perhaps.
Senator Cran.
Madam Chair, thank you. I'd like to move the A2 amendment to Senate File 4223.
Senator Cran moves the A2 amendment. Would you like to talk about that amendment?
So, Madam Chair and Senator Westlin, we've talked about it and I've worked with Mr. Sigurdsson really around the sign language that I believe Mr. Senator Marty brought and talked about last year. And so when we met, we talked about it and reviewed it and would have preferred, in which what we did is we changed the from a percentage of a sign to a fixed value, or in the case of our smallest signs, a minimum fixed size or a minimum size standard. But then also we made some changes to fit the sign utilization. So Mr. Sigurdsson brought us the national or the federal standards, and so we took the 5% federal standard, just put them into actual measurements. And then the only category we changed is the category, I'm not sure, when it talks about a sign that's smaller than 2 foot by 3 foot, or I'm sorry, that's greater than 2 foot by 3 foot, and the national standard is, and then, but smaller than 4 foot by 6 foot. There was a category that doesn't cover our most common 4 by 8 foot signs that we use in Minnesota. And so we just expanded that category to reflect the 8 foot sign, and then put, of course, the 1 inch size on it. And then anything over 4 foot by 8, which also previously reflected 4 foot by 6 foot, which is really into the billboard category. And so we put a fixed size requirement there. So that was really all the changes from that perspective. The rest appear to fit. And we see the reason the percentage, when we had problems last year, is the orientations of the signs are changing. People are using elongated now. And so if you measure the height, it kind of blows it up. So I think we're covered with kind of everything we see in Minnesota today. So thank you.
Madam Chair.
Senator Westlin.
I will say this is a friendly amendment.
Awesome.
This is a truly bipartisan bill.
Senator Marty.
Madam Chair, I think it's a good amendment too, but I was curious, has it always been, maybe Mr. Sigurdson knows, but has it always been required that the disclaimer be printed in high contrast on a white background? Because I keep picturing a lot of signs candidates have, the background is red or blue or other things, and it's often done with white ink on that. Is it always been our disclaimers are supposed to be on a white background?
Mr. Sigurdson, please introduce yourself and answer.
Thank you, Madam Chair. Jeff Sigurdson, Executive Director at the Campaign Finance and Public Disclosure Board. No, Senator Marty, there hasn't been that standard. That's, again, bringing forward what's a fairly standard FEC requirement. That's in part why you see in the original language that there is an exception for for signs that already exist, because we do realize that there are a number of signs out there who aren't using that white background or black text either.
Senator Corinne.
Thank you, Madam Chair. And Senator Marty, you know, I reviewed that as well. That white background, I pay attention to a lot of those signs when we consult in campaigns all around the state. That white background with the high contrast shows up the best in all lighting conditions, and so I think you get the easy, most legible, most readable from in all light conditions. It does show up the best, and I don't think it imposes any burden. They'll just stop the screening for those that choose to do the full, the full screen print instead of white on or having a white background. They got the darker colors, so I think it'll work well.
Senator Marty?
Madam Chair, I was just surprised. I've seen some candidates who print on like a yellow plastic or something, and I don't know if that counts or how they deal with those sorts of things. It's not a big deal. I just kind of wondered if people are going to have issues with that. But okay, thanks.
Senator Barr. No. I'm the yellow guy. Very good. Yellow signs. Any other questions or discussion about the A2 amendment, members? Seeing none. Okay, so we will vote on the A2 amendment. All those in favor say aye.
Aye.
Aye. All those opposed? The A2 amendment is adopted. Senator Westlin, any other comments before we move to members?
I don't think so, but boy, it's going to be awkward at your Thanksgiving, you guys.
Senator Westlin, apologies. Before we move to member questions, I see we do have some testimony here. I will welcome Mr. Sigurdson. Please introduce yourself again and present your testimony. Thank you.
Madam Chair, again, Jeff Sigurdson, the Campaign Finance Board. The only thing I was going to offer the committee, if it's useful, is to run down the sections of 4223, but it depends on how much time, frankly, you want to spend on that. If it's more in terms of members would prefer to address particular sections with a question, that's fine, whichever approach you wish.
Thank you, Mr. Sigurdson. Maybe we will take the approach if members have questions, we will move in that direction. Before we do that, I don't have anyone else on my list to testify. Anyone else here who would like to testify on this bill? Seeing no one coming forward. Members, questions? Senator Barr.
Thank you, Madam Chair. Just one quick one. I probably should have got this in before we adopted the amendment on the signs, but all signs currently in use are grandfathered in, correct?
Senator Westlin.
Madam Chair, Senator, yes, that was part of the change that we made on the effective date, was we removed that. And the language on the 4.15 to 4.17, signs printed prior to January 2027 that do not comply may continue to be used after that date and are not in violation. So we are grandfathered in We don't have to go spend thousands of dollars on new signs.
Other questions or discussion, members? Seeing none, any closing comments? Senator Westlin?
None.
All right, this bill will be laid over for possible inclusion in an omnibus bill. And with that, we will move to Senate File 4143. Senator Westlin.
Thank you, Madam Chair. So this was a provision that came through last year and unfortunately came out in conference committee. So if you look at Senate File 4143, it is a fairly simple bill. As you know, there are some organizations and entities that send out absentee ballot applications to individuals, and currently they are allowed to pre-fill certain fields. My concern has always been and continues to be that if someone receives a pre-filled ballot application and it has any kind of misspelling, if there's any error in the address, if the person is actually moved, if they have been married or divorced, their name's changed in any way, it's pre-filled, and if they don't notice that, that could create problems and issues for them. My bill would allow organizations to continue to provide applications and highlight all of the fields that need to be completed, but it would not be pre-filled with information. And I do understand that there have been concerns raised that there may be individuals who might require additional assistance to complete absentee ballots, but if we have individuals who I think are referred to as perhaps low literacy individuals or individuals have difficulty reading, my concern is that would actually impede their ability to verify the information on the application was correct. So again, it's a pretty simple provision. I am going to try to get this over the finish line again this year, and I'm happy to stand for any questions.
Any questions or amendments? Oh, Senator Corinne.
Thank you, Madam Chair, and Senator Westlin. I think we all appreciate the removing the ability to preprint. Last year we added the disclosures so people would at least be able to identify where they came from. We have all heard the confusion out there because of this process and unknown entities constantly putting them out there, confusing our voters. So we appreciate it. Thank you.
Madam Chair, just be clear, I'm
Westlin.
not even necessarily, assuming any nefarious intent. It can create confusion for people who get the application. And again, if there are any errors on it at all, I would hate for an absentee ballot to be submitted with incorrect information, which would actually impede the ability of that voter to actually vote.
Any other questions or comments? Seeing none. Any other closing comments, Senator Westlin?
None.
All right, this bill will also be laid over for possible inclusion in a future omnibus bill. And with that, members, we are adjourned.